Further hearing the appeal of the Republic Parliamentary Acting Group Attorney General against Privinvest Shipbuilding SAL holding an up.
Good morning, Mr. Matthews.
Morning, my lord. I'll come back, if I may, in a little more detail to the various heads of claim, but I wish to start this morning where we left off yesterday, addressing one particular aspect of the claims against the respondents based upon their pleaded case.
Could I raise one point with you before you do that, so that I don't then take you out of your stride? And that is the precise assumption on which this court is being asked to proceed. Now, Mr. Justice Waxman, at paragraph 45 and 46 of his judgment at MS 842, records an agreed assumption, which is that the Republic, although not an express party to any of the supply contracts, is nonetheless bound by the relevant arbitration clauses. And he goes on to hold in 46 that cannot alter the fact that the claims that he is considering are made on the basis that the Republic isn't a party to the supply contract. Are we to proceed on the basis that that is the extent of the agreed assumption?
In relation to the Republic?
In relation to the Republic.
Yes, as far as we're concerned, my lord.
My lord, that is correct.
Fine. And secondly, where do we see the precise assumption in relation to the logistics subcontractors?
The best place is where I showed your lordships yesterday, because it's not clearly spelt out in relation to in either the judgment at first instance or in the Court of Appeal, but it is spelt out in the skeleton argument of the Republic, which I showed your lordship yesterday, and which I will give your lordship a reference to.
Yes. So for the subcontractors, we looked at the skeleton argument as the agreed position.
My lord, yes.
Is it not stated in either judgment, or is it?
My lord, the assumption is a defined term in the Court of Appeal judgment, but that relates only, as I recall, to the position of the Republics, rather than to the position of the of D9 and D10.
Right.
I mean, paragraph 69 in the Court of Appeal's judgment does touch on this.
My lord, yes, and I was seeking to identify for your lordship because the Court of Appeal identifies a capital A assumption, which is defined at paragraph 28 of the judgment, but that only deals with the position in relation to the Republic. Paragraph
69 is dealing with the logistics companies.
My lord, indeed, yes, I was agreeing with your lordship. I'm sorry.
I see. Yes.
It is set out there that whilst they were entitled to invoke the arbitration agreements, and that is the assumption upon which one proceeds. And as the Court of Appeal also points out, none of the parties saw any material distinction between their position D9, D10 and that of D6, D7, D8.
Yes, I mean, that is clearly the assumption. It might strike one as odd that subcontractors who have no direct contractual relationship with the special purpose vehicles are entitled to invoke an arbitration clause. But if that's the assumption you're asking us to proceed on, so
it's even more odd that a subcontractor who's not even a subcontractor of the party is entitled, apparently, to invoke the clause. I mean, I know that the passage you showed us in the skeleton argument was in question, but I wonder whether it really is a concession that that all subcontractors can take the benefit of all arbitration clauses, whether or not they're in the chain or not.
It is the assumption on which the scope issue has been hived off, because it is the highest at which the case can be put as a matter of Swiss law. It may not be the ultimate outcome of the Swiss law determination of the parties.
What's the nature of the Swiss law principle that says anybody can claim the benefit of an arbitration clause?
It is not. It's not quite that wide, my lord, but it does involve questions of either interference with the contract or involvement with them, or being intended to be the beneficiary of the rights and obligations under them. There are two different approaches under Swiss law, but it is very much a civil law concept which has never found, or not yet found, favour in English law, as the adherence of non-parties to arbitration agreements and indeed to contracts more widely. It is, but I tread cautiously here, it is likely to be, although ultimately this will be a matter for the arbitrators, we say, the explanation of some of the thinking behind the terms of the contracts which your lordship has been shown in relation to the extent to which rights and obligations in relation to other non-parties may or may not be embraced, akin to the third-party rights concept under English law, statute law, but many civil jurisdictions have concepts of group liability or group obligations and group adherence to contracts in a way that we haven't, again, developed in quite the same way. So that they are fundamentally different concepts of civil law and of Swiss law, very different from where English law has developed or yet developed, and very much, we say, ultimately a matter at most arising on the parties' part of the Section 9, but more realistically, we say, arising on the arbitration, in which it's the burden and duty of the arbitrators to determine and construe the clauses in these Swiss law contracts subject to arbitration agreements.
Thank you.
One further point of clarification, if I may. We were shown yesterday the amended particulars of claim, and you referred us to page 420 and to paragraphs 27 and 28. The paragraph 29 shows what the Republic is seeking, and at that stage anyway, it seemed to be seeking a declaration of no liability in respect of the guarantee for the pro indicus. But am I to take it that pro indicus transaction? Am I to take it that it's wider than that? That it's what about other guarantees or, in respect of Ematum and MAM?
The position, as I understand it, is that the claim does ultimately go wider than that.
Yes.
In relation to the MAM guarantee, the Ematum is a slightly more complex one because the nature of the obligation was converted. So it is not wholly clear, but obviously from a practical point of view, from the perspective of the respondents, we are concerned primarily with the implications of Roman II, the further relief. The implications of Roman I come against the respondents indirectly,
yes,
on the basis that if and to the extent that Credit Suisse lose the protection, as it were, of the guarantee in relation to the loan facilities, then they come after us.
Come after you, yes.
And so that is why we refer both legally and factually to the Credit Suisse claims as parasitic. And one of the ways in which it is said, oh, well, it cannot have been intended that the arbitration agreement should cover a claim like this, because look, the Credit Suisse case against the parties is not subject to an arbitration agreement and is going to continue in any event. And the short point we make in relation to that, and I'll just pick it up now, is that the fact that the Credit Suisse position is different doesn't really in practice arise, because if the Republic's claim in relation to the bit that I'm now going to come on to show you fails, then the parasitic claim of Credit Suisse also fails.
Yes. Well, thank you. The reason I asked that latter question was simply because I noted that Mr. Justice Waxman referred to an attempt to have a declaration that guarantees under the pro indicus in the Martin contracts were they were seeking a declaration that they weren't binding, and I wondered whether what the position was in relation to MAM, but no doubt this can be clarified by Mr. Pillow in his reply submission. Thank you very much. I'm sorry to take you away from your theme.
Well, not at all, my Lord. And indeed, these paragraphs of the amended claim was where I was going to start this morning. So that's very convenient. If we go, in fact, to page 419, in the pleading, starting at paragraph 26, that this is the summary of the claim, the Republic's own summary of their own claim, and it says in terms that the claim arises out of 3 transactions between the SPVs and the Privinvest Group. Those transactions are and can only be described as the supply contracts, because it is the supply contracts to which the SPVs and the Privinvest Group are parties. So the starting point for the Republic is on their own case that their claim arises out of the supply contracts. If one bears in mind the terms of the arbitration agreements, it is, we would submit, an inauspicious start for the Republic to say that their claims arise out of the supply contracts and are yet not subject to the arbitration agreements within those contracts, to which, on the premise that we're proceeding, the Republic is also a party, not just the SPVs. Why does the Republic say that their claims arise out of the supply transactions? We get the answer to that from looking at what is their actual case on the pleadings. And what Mr. Pillow has done a lot is to focus on a theoretical case of what might be said differently to be the case that they might have run on the facts. But I would invite the court to look at the case that they actually do run and on the factual basis on which they do run it. And we get that best from the further information of the pleading, which one would expect is their careful and collected thoughts in relation to how precisely they advance their case. And if we go to that at paragraph 26.2, which is in the bundle at 471 at the bottom of the page, we see that their case is that the Republic contends that the pro indicus supply contract was an instrument of fraud because the parties to it did not intend it to be a genuine procurement contract for the supply of goods and services at market value, but a vehicle for the enrichment of the first to 10th to 12th defendants at the expense of the Republic. And without limitation, they say, the goods and services were selected to justify the fact and level of lending, and in turn to accommodate the level of bribes and or secret commissions promised, paid or to be paid by Privinvest, and not to satisfy any genuine need for those goods and services and or to ensure the feasibility of the transaction, The
I
parties...
thought this was the subject of their concession, that they are not... they accept that they can't pursue this as against you.
If your Lordship would just bear with me, I'm going to take it through the pleadings and then see what's left. That's the point.
Okay.
They would love to strip this out. That's why they made the concession. But they can't. Because on their case, on the facts, this is the way in which their case, not only in relation to the IFA, but therefore across the board, is structured. And this is what they say is, in fact, the underlying case. The attempt to strip out the IFA is a strange one, because there are two different reasons why the IFA might be a bad way forward for the Republic. One is because it's covered by the arbitration agreement. The consequence of that would be, technically, it stays on the pleadings, as has been discussed, and the court and the parties then have the burden of working out what the implications are for the issues that then are left and that actually arise once you strip that out. But it's left there on the pleadings for a variety of reasons, not least because, as for example with unfair prejudice claims, where the claim is stayed, it can nevertheless go back to the court in the event that, for example, the arbitrators might determine that there is unfair prejudice, but a remedy that is sought in consequence of that might be the striking out or some other, the winding up rather of the company, and you then go back to the court on the basis of the arbitrator's findings for them to deal with that aspect. And so you don't strike out the pleading in relation to the bit that goes to arbitration. It remains there, but it's not proceeded with in the court proceedings. It awaits, as it were, the outcome, or it may not, depending upon the case management of the rest of the case.
Do you understand the concession as regards the IFA to relate only to the claim against your clients? In other words, does it remain live in the court proceedings as against the Credit Suisse defendants and Mr. Saffa?
That is my understanding of the extent of the concession, yes.
Yes, I see. So the position at the trial, if that's what happened, would be that that case would be before the court, it would be fully argued, but it wouldn't be a sort of allegation as against your clients.
Indeed, my Lord, and
yes.
As a matter of case management, in consequence of the decision of Mr. Justice Knowles, that is precisely what is going to happen.
That is what's going to happen.
Whatever the outcome of this.
Yes.
Yes.
Right, okay, thank you.
And so that issue remains live, remains to be ventilated between the other parties. And that's why I say that the other way in which the IFA may be analysed is not on the side of is it subject to the arbitration and therefore must go, but almost the way in which my Lord Legate was approaching it, which is, well, actually, what is the legal analysis of the IFA? Does it have any legal significance at all? Now, if the answer to that question is no, then the point is as bad against all of the other defendants as it is against my clients, and it's not in that sense that it should be off to arbitration. It shouldn't be on the pleadings at all. Now, the point is, it is on the pleadings, it is the Republic's case, and it is the case that we have to meet.
Well, that's the bit I don't understand. Why do you have to meet it? Why do you have to meet it?
Because it is, as I'm coming on to show, the basis on which, for example, the bribery allegation is advanced. I'll come on to show this, if I may. But
I mean, that seems to lead to an argument there isn't a bribery claim against you, rather than that something needs to go to arbitration. I mean, if they've made a concession, which means that there's no longer a sustainable cause of action against you, then that's the end of that, isn't it?
that is not the concession that they have made. Right. That has been ventilated.
Well, the concession is that the IFA is not an issue as between them and you.
The difficulty with that is that the IFA underlies their bribery claim.
Even against you?
Yes.
Well, that's what you'll have to show, yes?
Yes. Well, that is...
I mean, we understand the IFA, and these, as my Lord Legate has pointed out, are particulars or information given of the IFA allegation.
They are particulars of the IFA.
One particular aspect, it seems to me at least to have two aspects. One is that these weren't contracts at all. They're not genuine. They just pretend to be contracts, which seems to be what they're giving particulars of here. The other part of it seems to be an allegation that if these were contracts, they weren't for market value, which, as far as I can see, would be of evidential significance but of no legal relevance to anything.
What their case is that they're advancing here is that the contracts were to fund, amongst other things, bribes. That is their case in 26.2b. The parties to the contract, which on this analysis are the SPVs and the Republic, intended that the contract price was to be used wholly or partly to pay bribes.
I can understand partly. Wholly does seem a rather extravagant allegation.
My Lord, indeed. But what I'm trying to address is the case that my clients have to meet.
I understand the point you're making.
And it ties into what we touched on at the end of last night when your Lordship said, well, how can there be two tests? I'm not suggesting that there are two tests for what the court is invited to look at. The court is invited to look at what has been pleaded, but it is always open to the court, and it is appropriate for the court to supplement that, not to derogate from it, but to supplement that by an analysis of what in fact is or are the real issues in issue between the parties, regardless of whether the claimant has so sought to fashion its claim as to obscure that issue artificially. And that is why, and it is therefore, for all parties concerned, you start with what are the pleadings. You don't ignore the pleaded case, because that's the case my clients have to meet. It's very easy to say, oh, that's not a good claim, is it? I mean, that's not going to be successful or whatever. That may or may not be true. For all we know, by the time we get to trial, English law may be further developed on the basis that the bribery has to have some connection with the transaction as a matter of law or not. That may or may not be. The fact is, I have to meet the pleaded case as the starting point. And that is therefore the starting point of the analysis as to whether the pleaded case engages under Section 9 with matters that are agreed to be referred to arbitration. And so if we look at the pleaded case in relation to the bribery, yes, this is a particular of the IFA, but it is inextricably linked with the bribery case. Because what is said to be the position is that the contract price under the supply contracts was to be used wholly or partly to pay bribes, or to recoup bribe payments made. So the way in which it's advanced in this pleading raises foursquare, not just in the context of the IFA, but also in the context of bribery, that this supply contracts are the vehicle, the route for the payment of the bribery, and that they have been concluded in order to pay bribes. Now, that is a case that my clients have to meet. And at 26.3, as to the legal consequences flowing, they say the pro indicus supply contract was in the premises illegal and contrary to English public policy. And so that is then encapsulated in the re-amended pleading, which we have at in two key places, 1127 at paragraph 79.7, and again, I fully accept that the location, as it were, in the pleading where this is dealt with begins with the paragraph 79 at the top, which we should have on our screen just momentarily in fairness. It begins with the Martin supply contract was an instrument of fraud, alternatively a sham. The parties to it did not intend it to be a genuine procurement contract for the supply of goods and services at market value, but a vehicle for the enrichment of the defendants. Well, we've seen the expansion of that in the further information. It's for the payment of the bribes and the enrichment of the defendants. And then at 7, Romans 7, the fact that the services purportedly to be supplied under the Martin supply contract were selected by a DM acting through Mr. Bustani and in turn Mr. Saffa to justify the fact and level of lending to be provided under the facility, and in turn to accommodate the level of bribes and or secret commissions promised, paid or to be paid by Privinvest, and not to satisfy any genuine need for those services and or to ensure the feasibility of their Martin transaction. And it's to similar effect at paragraph 87, Roman 5, on page 1129. One of the difficulties is it's not the easiest claim to navigate even before it's re-amended, but it is essential that one has as clear as possible an understanding as one can of what the claimants say is engaged to be addressed. Now,
that's only in relation to the IFA claim. I mean,
but that is the source and context of the bribery allegation.
I think it would be very helpful if you made that connection for us on the pleading, because I think we do understand the IFA claim, and one can see how it would be a powerful allegation against your clients, but it isn't an allegation against your clients by virtue of the concession. So where is the bridge between this and the bribery claim? Where do we see that?
Well, first of all, the bits that I am showing your lordship.
We see this, but if you can show us on the pleadings how the bridge works.
Well, it's very difficult to extract exactly how the bribery case is advanced, but I'm going to come on to it and do it without looking at these other bits, because they're intertwined. Because what happens is that reliance is placed interconnectedly on all of these bits. When one comes on, there's no separate claim in the way that the Republic is trying to present to the court a theoretical way in which the bribery allegations could be presented, wholly in isolation of the allegations made in relation to the IFA. But they're not. That is not the pleaded case. You do not find on the pleadings this case in bribery that is somehow shorn of and separate from and distinct from the IFA. And that's exactly...
but they plead in paragraph 129, this is in the amended consolidated points of claim 441, a simple pleading, that the CS deal team defendants and the Mozambique officials received the bribes.
They plead at paragraph 130.
Well, that's as against Credit. That's as against Credit Suisse.
Well, my lord, yes, but we are said to be co-conspirators. We are said to be.
Yeah, but I mean, 130 is not an allegation against you. Can't be.
Well, it comes in as an allegation against us because at paragraph 131. It says, in the premises, the defendants.
Well, that can't, as against you, include 130.
But that is the pleaded case, my lord. I entirely appreciate that, and this goes back to the problem.
I don't quite understand how in 130 they can say, as against Credit Suisse, and then in 131 say, and also, therefore, as against you.
There may well be infelicities in the pleading.
I don't think it is an infelicity, is it?
I'm so sorry.
I don't think it is an infelicity. It seems to me naturally to follow from the. I mean, so far as 131, as far as your client is concerned, follows from 129, doesn't it?
Well, we struggle to see how that can quite work, given that at 130 it relies upon paragraphs 50 to 93. That includes paragraphs 63 and 64. If we turn to 63, we see in relation to the Pro Indicus contract, and the same applies in relation to the other two.
This is on page...
427.
Thanks very much.
The way in which it is pleaded is that on or about that date the Pro Indicus supply contract was entered into. On the face of the supply contract, the supplier was to supply various assets and services, including radar stations, vessels and aircraft, to enable the Republic to monitor and protect its EEZ. The Pro Indicus supply contract was an instrument of fraud.
Yes, but that's
We
not...
keep coming back to that, but we're told that they accept they can't rely on that part of the pleading against you. So that's it, isn't it? Unless you could show some other part that does bring in the supply contract,
Well,
and that they are alleging that it was invalid because of bribery.
As I said, there are two difficulties in relation to this. First of all, there's the question of whether the allegation should be being dealt with by way of arbitration. The second is whether it is a good allegation in law. It is the substance of the way in which they put their case against my clients in relation to bribery. It is adopted. You cannot...
I don't follow. I simply don't follow that. Insofar as the claim in bribery is concerned, it doesn't matter where the money came from, where the bribes came from.
Your Lordship is saying that, which may well be right as a matter of English law. It may not be right as a matter of Mozambican law, and it may not be right when this matter comes to be argued at any stage. The point is, what is the pleaded case against my clients?
You seem to be going round in a circle.
I'm sorry, my Lord. That is...
Well, once we strip out the instrument of fraud allegation, I don't at the moment see that there's any pleaded case that the supply contracts were invalid because of bribery. And they don't need to plead that because they can establish that the guarantees are invalid because of bribery without having to prove that the supply contracts are invalid because of bribery. And they can accept, as indeed I understand they do, as against you, that once you leave out the instrument of fraud, that they can be assumed to be valid.
Well, that doesn't work because of the factual basis upon which they advance their case.
But that simply shows that the facts that they prove would support a claim to invalidate or set aside the supply contracts. But that isn't the claim they're making against you.
What they are making against us is a claim which says that the bribery was performed by way of entering into supply transactions to provide financing, to provide funding to bribe. That is the way in which they advance their case.
Well, only in the instrument of fraud paragraphs.
Well, if they don't do it in that way, then where on the pleading, as it were, is this clean plea of bribery shorn of the IFAs? And there is
Paragraph 129.
Well, that is a list of bribes allegedly set out.
Allegation of bribery by the defendants of the Mozambican officials.
But the allegation in relation to that is clarified or explained in the further information, that the context of the bribery is directly at the centre of the allegations in relation to the supply contracts, namely that the supply contracts were entered into in order to fund the bribes. And this is the difficulty. That, as the Court of Appeal, we say, rightly recognised, is why the IFA lies at the heart of the bribery case as well, because the way in which it's pleaded against my clients means that that is the reality of what their Republic's bribery claim is being advanced. That is the factual case. It is inconceivable or very difficult to understand quite how that they will, and they certainly haven't on their pleadings, come before the court in October and say, we do not assert that the bribes were designed to be funded out of the supply contracts and that the bribes took effect if and only if the supply contracts were entered into, and the supply contracts were the vehicle for the payment of bribes. That is the case which they're advancing. And if one looks at their case, it is simply that the bribes and enrichment of the respondents was how the supply contracts were entered, how and why they were entered into, in order to provide funding for the bribes. Any analysis of the circumstances of the alleged bribes, under whichever system of law, is going to involve investigation of the Republic's case on the genuineness of the supply contracts. And we've developed this also further in our case sorry, I've got it's the wrong one. It's not credible that the Republic would lose on its allegations concerning the supply contracts and yet still win on bribery, not least because it has no such pleaded counterfactual. Any analysis of whether the payments were bribes on the Republic's case involves an analysis of their case on the truth about the supply contracts.
Would you accept the statement of the law of bribery that Mr. Pillow gave yesterday, that it's unnecessary to show that it procured the entry into any contract that, and so forth, the four propositions that he took from Novership, or is there any dispute about the law?
There is. I don't dispute that under English law.
Well, that's all we're concerned with in this case, isn't it, English law?
Well, except that our case is a foreseeable defence also under Mozambican law. But under the Mozambican law, the position is not so clear-cut.
Okay.
But even under English law, the position is you still have to establish that this payment is a bribe or that it is, in effect, such as is designed to compromise the confidence of the receiving party. And if you then ask yourself the question, what is the factual case on which the Republic rests for establishing that, it is to say the bribe was part and parcel of the supply contract.
Why can't they just rely, and I thought they did, on the fact of payments being made to the Mozambique officials?
Because the mere fact of payment to a Mozambique, if I agree to buy a car from a Mozambican official and I pay him the value of the car, it's not a bribe.
Not from the Mozambique official. You agree to buy the car from the government, but a separate payment is made to the Mozambique official who's negotiated the sale on behalf of the government.
No, sorry. My example,
Yes, I know, but I'm trying to bring... I mean, your example is not an example which is analogous to this case.
But it is, my lord, because you have to work out why these payments were made.
Well, they can say, look, these payments were made in this context. The natural and obvious inference is they were bribes. Then the evidential, of course, the legal burden never shifts, but the evidential burden would shift to your side. Say, no, they were legitimate payments of election expenses.
And when one looks in that context, what is their case on saying these were not legitimate payments? What is their case, if we can just stick with my analogy for a moment of saying this wasn't a payment for a car? Their case is this was a payment which was promised or given as a vehicle to enter into the supply contracts.
They don't even have to show that, do they? I thought it's enough to show you paid the agent a secret commission.
But it begs the question of
whether the agent was motivated by it, you don't have to show.
No, but you still have to show that it was a commission.
Well,
and that's the problem.
A sum of money.
No, simply showing that he's paid a sum of money doesn't work because he could have been buying a car. That's the point. You have to show that it's a commission, that there is something about the payment which makes that payment corrupt.
Well, I mean, this is all occurring in a context, whereas Mr. Justice Waxman records in paragraph 19 of his judgment that as far as the CS team is concerned, Mr. Singh admits receiving 5.7 million by secret commissions or kickbacks from Privinvest. Mr. Pearce accepts that he received £45 million of payments from Privinvest, but he denies that it was secret commissions. And Ms. Subeva says that she received money indirectly from Mr. Pearce. I mean, I think there needs to be an element of reality here. One side of the, certainly some members of one side of the transaction, i.e. the Credit Suisse team, one at least, Mr. Singh, is admitting that he's got a kickback from him. So the burden on the claimant of showing that these payments were secret commissions may not be quite as great as you're suggesting.
If you add into that mix the context of plea bargains in the United States and terms of plea bargains, but as I pointed out, a matter in which my own employee, Mr. Bustani, I referred to him yesterday as managing director, but I think he's a sales executive, he was acquitted of those charges.
This has nothing to do with plea bargains. This is to do with the defences lodged in this litigation.
Yes, but not by my clients.
No, not by your clients.
So the issue which is going to be addressed in my clients is whether they did in fact receive those payments in those terms or whether they're accepting that they did as part of their plea bargains.
Yeah.
So the position is that going back to the fundamental point of establishing that a payment is a bribe, it has to be shown that it is, that in that sense, a commission, that it is a payment that should not have been made to the person in question. Now, if you look at the Republic's case on what is the counterfactual in relation to that, it is the instrument of fraud allegation. It is that these supply contracts were entered into in order to achieve payment to, amongst others, these people by way of bribes, not that it was a genuine contract. Now, if that falls apart, then the nature of those payments, on the basis of the Republic's case, fails. They are not commissions.
To be honest, I don't see that. I mean, it seems to me that the IFA is an allegation of the mechanism by which the bribe was funded. It is saying nothing about what was the purpose of the bribe. The purpose of the bribe, presumably, was to obtain profitable contracts from the Republic of Mozambique's SPVs, but the fact that the bribes were funded by the price in the supply contracts, it isn't an essential element of the bribery claim.
But the bribery claim proceeds on the factual premise that the purpose of the supply contracts was, in part at least, to fund the bribes.
Yeah.
Whereas our case is that the supply contracts were not in part to fund the bribes, but were genuine commercial transactions at proper market value, and that none of the payments in relation to the alleged bribes can be said to have been caused by or triggered by the entry into the supply contracts.
Well, that won't be a defence to the claim. If it's proved that bribes were paid to Mr. Chang, that's all they have to show. But to sign the guarantees.
But we are going round in a circle in the sense that that is not the case that I have to meet. The case that I have to meet is that the circumstances in which the supply contracts were entered into was to fund bribes, and that it is those payments were commissions or and therefore bribes, and in order. And the supply contracts were entered into in order to fund the payment of those bribes.
Why is that an essential element of the claim?
Yeah. It wouldn't matter if the money comes from somewhere else. It'd still be a bribe.
It's not the Republic's case that it came from somewhere else. It's the Republic's case that it came from and was funded by the supply contracts, and that's an essential part of their case, that the payments were themselves corrupt.
But it's no part of their case as against you. I mean, the result of this, if you're right that their case depends entirely on showing the IFA, establishing the IFA, and given that the concession is they can't rely on the IFA, there is nothing in this claim. You could go happily into trial knowing that you would succeed.
Wholly or partly is sufficient for my purposes.
Wholly or partly? What? Sorry.
The purpose of the supply contract was wholly or partly.
Yes.
Sorry,
No,
the case on bribery is wholly or partly.
Yes.
Based upon the IFA. If, therefore, we need to engage the IFA in order to address their case on funding, which we clearly do.
Because it's no part of the case against you.
But that's to strip out in isolation a part which is clearly, nevertheless, a part of it. I mean,
that's where I haven't got over this difficulty yet. They have conceded it's no part of their case against you. That's a great bonus for you, you may say. So they can't rely on any of that against you.
But the difficulty is that is their pleaded case.
Well, in that case, there's no case, as I said. If you're right in your analysis of their pleading, then their concession means they have no case at all.
The same point applies to the suggestion that the payments were dishonest. Again, the factual premise upon which the allegation is made that the payments were dishonest is that the supply contracts were entered into in order to fund them.
Well, it needed. I mean, if it was a bribe, then it was dishonest. Yeah. It doesn't matter where the money came from, just going back to points previously made.
Yes.
So what you're saying is that properly read, this pleading has as an essential ingredient, as against your clients, that the bribes were funded by the supply contracts. That that's an essential part of their bribery claim and their dishonest assistance and their conspiracy claims, as I understand it.
Well, it is undoubtedly a part of their case on the bribery allegation, as
Again,
I have sought to show you, as to how they get to the nature of the bribes. They say these payments were made by way of commission, and the supply contracts were designed to, as it were, raise the money to fund those bribes. That is the case that we have.
The point you're making now does not seem to me to have been formed part of the Court of Appeal's reasoning at all.
Well, it does, because they summarised it by referring to validity, etc., of the supply.
They said that it was that the essential point was that it was a complete defence for you to show that these were wholly valid, proper, and commercial contracts. That was the line that was taken by the Court of Appeal. I mean, I don't know. It's not. I mean, frankly, I have doubts about that, which you may want to address. But it wasn't anything to do with how the bribes were funded. I don't remember any reference in the Court of Appeal's judgment to that point.
The approach the Court of Appeal took was, in paragraph 105, compendiously to deal with it. But the reasoning that I have outlined is part of what underlies it, not necessarily entirely expressed in the judgment. But
I must say I read that as a different point.
What it is addressing is that the case against my clients, that the supply contracts with the facility agreements, the guarantees and the bribes were together and each the key elements of an allegedly fraudulent scheme. The fact that a key aim of this conspiracy was pleaded as being the provision of the guarantees does not alter this. It's not said to be the sole aim. The supply contracts were a key element of what is said to have been a single fraudulent scheme, allegedly designed to achieve that aim. So what they're addressing there is the fact that we have to demonstrate, or the case against us is that there is a fraudulent scheme. The part of that involves the funding of bribes out of the supply contracts. And therefore, if one comes back to the question of what the case that we have to meet is, answer in relation to bribes, it is that the supply contracts were entered into in part to fund the bribes. which goes to the very basis of the way in which the bribery allegation is advanced against us. And at paragraph 110, under the section dealing with the claim for bribery, the Court of Appeal goes into some detail as to why the claim for bribery is, and inevitably is, infected by the way in which the bribes are alleged on the facts to have been developed. Halfway down, the bribes are alleged to have been paid in furtherance of the alleged fraudulent scheme involving all three transactions. This is the substance or the reality of the dispute, including the bribery claims.
Yes, I must say I hadn't read that paragraph as involving any suggestion about the source of the funds. I thought the point being made was that given that if you regard the supply contracts, the facility agreements and the guarantees as part of a single composite transaction, you can't separate, say that the bribery related just to the guarantee. It related to all elements of the transaction, and since one element was the supply contract, it had to go to arbitration. That's what I thought the Court of Appeal was saying there.
Yeah, partly, yes, but it's also addressing the point that the supply contracts are entered into on the Republic's case as part of a vehicle by which to fund, amongst other things, the bribes. And therefore, you cannot sensibly divorce the bribes paid to secure the various different contracts. They are alleged to have been paid in furtherance of the scheme. And that is, therefore, what we have to engage with on the pleaded case against us in relation to the payment of the bribe. And if one is examining the Republic's case on what is said to be the circumstances which make the payments bribes, namely that it's part of a fraudulent scheme in order to fund bribes in part through sham non-commercial, illegitimate commercial transactions in the context of, namely, the supply transactions.
But that isn't what makes it a bribe. What makes it a bribe is it's paid to the agent who's about to sign the contract. If you pay the person you're dealing with a sum of money, he's about to sign the contract on behalf of his principal, and he doesn't disclose that payment to his principal, it's a bribe.
It's a bribe if it's not a legitimate transaction. It's not a bribe if it's a legitimate transaction between the third party and the agent. And the question is what makes it an illegitimate transaction, what makes it a commission rather than a legitimate separate transaction. And our case,
I'm not aware of that aspect of it. I thought that the elements of bribery are that you know the person you're dealing with is an agent and that you make a payment to him which he doesn't disclose, which you don't tell the principal about, and he doesn't either. And that's a bribe.
Not if you're buying his car. Not if it's a perfectly legitimate transaction for the purchase of a car.
Buying his car separately, you mean, from the transaction you're negotiating with?
Yes. If the payment is a legitimate payment, which of course our case is in relation to these payments, in those circumstances, you cannot demonstrate simply by the fact of payment that that is a bribe. It has to be shown to be some sort of commission, not just a payment. And how does the Republic's case work in demonstrating that these were commission payments? In part, at least, and that's all I need for my purposes, out of demonstrating that the supply transactions were part of an elaborate scheme to procure the payment of these bribes and to fund those bribes. And that's why, in part, they say that the payments were indeed bribes. And
I don't follow that. I mean, if the issue is why were the payments made and did they involve secret commissions, proving that the supply contracts funded the payments doesn't get you anywhere. The key that will have to be the key to the Republic's case will be that in all the circumstances of the case, the monies that seem to have gone to Credit Suisse and to officials of the Republic can only be interpreted as being commissions intended to obtain a result.
It is part of the Republic's case in relation to that the entry into the supply transactions was on terms and was manipulated in order to provide financing for the bribes. So that is part of their case as to why these payments were illegitimate.
But if the payments are shown to be illegitimate, the fact that they are not shown to be illegitimate, the fact that the source of the funds was the supply contracts won't help at all.
No, I'm sorry, it's not just that the source of the funds is the supply contracts, it's that the supply contracts were entered into in order to be the provider of funds as part of a dishonest and illegal scheme. That is their case, partly, at least, to show how these payments were bribes, rather than being, as we say they were, legitimate payments. Part of their case is we have these supply transactions which were concluded between the parties in order to fund bribes, not as genuine commercial transactions. And that is fundamentally a question which we say is clearly within the scope of the arbitration clauses. If you, we've set them out at paragraph 13, but to say that these contracts were entered into in order to provide funding for, in part, in order to provide funding for bribes, rather than being a genuine commercial transaction in relation to the supply of equipment, is clearly, we say, a dispute arising in connection with the project. It is also clearly a dispute, controversy, or claim arising out of or in relation to the contract, the supply contract in question, because it addresses the question of whether, as the Republic alleges, the supply contracts were entered into in order to fund, in part at least, these payments, or whether they were entered into, as we say, as legitimate commercial transactions fully justified on their terms, both as to amount, equipment supplied, necessity, the circumstances of their being negotiated and agreed between the parties, and that they were not the way in which, or intended to provide for, the payment of bribes to any of the people we're alleged to have made payments to wrongfully. And that's the key point. The mere fact of a payment doesn't in and of itself make the payment wrongful. It has to be a wrongful payment. It has to be, in that sense, a commission. And their case as to how it is they say, well, the supply contracts were completely concocted in order to enable these bribes to be paid. We say not at all. These supply contracts were genuine contracts, legitimate on their commercial terms, but what the payments that were made to these various people were unconnected to the supply transactions.
That's what you say, they were unconnected.
Yes, they were.
But they may have been connected to the guarantee.
The guarantee is not an independent item in any real sense, because the guarantee was simply the way in which the supply transactions were entered into. If there hadn't been the guarantee.
Paid for?
No.
How the supply contracts were paid for?
Entered into. There would never have been a supply transaction if there hadn't been a Republic guarantee.
Oh, I follow that.
Credit Suisse would not have given the funding without the guarantee.
No. And we would not have provided the goods under the supply contracts without the Credit Suisse providing the funding.
Correct.
So
yeah, I see that.
In that sense, it's...
But I mean, what I'm still struggling with is the idea that the supply contract has to be uncommercial and in bad faith and so on, in order for payments to Mr. Chang and others to be bribes. I mean, you can have bribery for a perfectly genuine contract.
You can. That is not the Republic's case.
Well, if you strip away the IFA, it is the Republic's case. It has to be, doesn't it?
The difficulty with it is that there are allegations in relation to bribery. It goes wider than this. It lies at the heart of their complaints in relation to dishonest assistance, where they say that there is dishonest assistance because of payment of bribes and entry into the supply contracts. Again, how do you establish that the entry into the supply contracts was part of dishonest assistance unless you demonstrate that the nature and circumstances in which the supply contracts were entered into are such as to give rise to the criticism which the Republic advances in relation to it. Similarly, in relation to the unlawful means conspiracy.
This is...
Now, I was going to come back to deal with some of these at a little greater length, but perhaps I should just pick up.
I thought they weren't relying on those subparagraphs as against you.
I'm sorry, my lord.
I thought they weren't relying on those subparagraphs as against you in relation to unlawful means and dishonest assistance. I mean, Mr. Pillow disavowed reliance on 1333.
It is.
And I think also on the 136.
I think they have a case of unlawful means, but they're eschewing as an unlawful means the supply, anything to do with the supply contracts.
Yes, just in case it does help, and I'm sorry to interrupt, we're not making any concession in relation to the dishonest assistance, my lord.
Just unlawful means?
Yes.
Okay.
Well, I'm grateful for that clarification. In relation to dishonest assistance, that they do yield or make the... Sorry. Could I clarify that again?
Yes, I think it's...
It was
Yes, if the court doesn't mind me interrupting. The concession we've made all along with the IFA is the UMIFA, which is 133.3. We have a case that the dishonest assistance claim is still entirely unrelated to anything arbitral in relation to the supply contracts, which I may have to reply on, but we aren't conceding that element of the dishonest assistance claim.
I'm grateful. And if one takes the dishonest assistance claim at paragraph 137 of the pleading, page 444 of the bundle, again, 137.3, which is relied upon, is the supplier's entry into the 3 supply agreements with the SPVs. But that goes to the heart of the question of whether there is anything reprehensible about the entry into the supply agreements with the SPVs. Because, again, it needs to be demonstrated that the entry was in some way dishonest. And if these SPVs were, in fact, legitimate commercial transactions, unimpeachable as to their terms, contents, and so on, how can there, we say, be any dishonest assistance by entry into the agreements?
Well, they say that the dishonesty is provided by the bribe, and the assistance is simply entry into the contract. It doesn't matter what its terms are, it's simply the mechanics of the operation of the bribe.
Well, my lord, firstly, that takes you back to the bribery question in relation to which I have already addressed in some detail. So that in itself derives some, is clearly linked with the supply contracts. The entry into the 3 supply agreements, again,
well, is your point on paragraph 137 is that what is pleaded is that by reason of the matters herein, and in particular at paragraph 62 to 93, and 136 above, well, 62 to 93 includes all the IFA allegations. And it is the first to 10th, so that includes your clients, dishonestly assisted in the Mozambique, etc. So far as this allegation is concerned, they are relying on the IFA as against your clients. That's the point, is it?
My lord, yes. I mean, and that is why, in relation to each of the heads of claim.
But that's on that one.
Well, I'm not sure whether they are or not, but they could no doubt indicate that they don't rely on it and they put it the way.
I thought Mr. Pillow said a moment ago that they were making clear they do rely on the IFA allegations as regards paragraph
only on
137.
137.3, as I understand it. Is it the assistance point?
May I again interrupt? I'm so sorry.
Well, I think it's a bit unclear. This.
I'm at the court. I know I shouldn't interrupt unless the court wants me to, and I can make it clear, I hope. Yes, by the concession on the unlawful means conspiracy third limb, we are dropping the UMIFA because we have dropped the IFA. We don't concede the dishonest assistance 137.3 because we regard that as having to work without the IFA. We have conceded the IFA for all purposes, but for the reasons my Lord Hamblin said, we don't need the IFA to make good our case on factual assistance in the context of a dishonesty in receiving bribes.
Does that mean, insofar as in paragraph 137 you refer to other paragraphs, including the IFA,
yes,
we are to exclude from your pleadings
yes,
those paragraphs which are purely IFA?
Yes, my Lord. And this is one of those problems that arises because we can't just delete the paragraph. If you can imagine it had been deleted, if it were a pleading solely against Privinvest, then this cross-reference wouldn't pick it up. I'm grateful for the indulgence.
It's one of the difficulties that the Court of Appeal had and that we have in trying to track the way in which the case is allegedly being advanced against us.
I can readily understand that.
And Your Lordship indeed asked yesterday for the possibility of a list of how the pleadings were said to be impacted, or which paragraphs of the pleading were said to be impacted, and certainly that's not something we've ever seen or has been made clear. And the position
the fact that we're having to clarify what the case against you is in the Court of Final Appeal is perhaps less than satisfactory.
My Lord, yes. That then means, from my client's point of view, in a substantial claim and one of great seriousness, we are in effect having to address the matters in some considerable measure on the hoof in the final Court of Appeal. The concession, as Your Lordships will appreciate, came on very late, close to the Court of Appeal decision. It wasn't fully worked through by the Republic as to the implications of it. And I have to proceed, and can only proceed, on the basis of what is the pleaded case against my clients. And if one takes the pleaded case against my clients, certainly without any detailed clarification of what doesn't arise on the pleading by reason of the concession, it is clear that the supply transactions are centrally engaged as to their justification, as to their legitimacy and their commerciality, their honesty, in the context of the different claims which the Court of Appeal, rightly in our submission, found were impugned or subject to the arbitration agreements in consequence. And the difficulty...
I think the Court of Appeal approached it, if I may say so. The way I read their judgment is they've fully taken on board the IFA concession. They accept it's no part of the claimant's case as against you, but it will provide you, they say, with a full defence, and therefore you're entitled and will to raise it, and you will raise it, and that necessarily goes to arbitration. That's the way it seems to me to have gone in the Court of Appeal.
My Lord, in our submission, they did it in both ways. They did it partly by reference to what is in the claim. They also did it by what is the defences that are likely to be raised. And Your Lordship is absolutely right that we do raise, by way of the defences, the points that we have to address and that I'm addressing Your Lordships on now. And they therefore, to that extent, infect all of the different heads of the claim. And that is why we say the IFA has not been abandoned by the Republic as demurrable or strikeoutable rather than a subject matter for the arbitration. They don't say that it isn't a valid and proper claim. They don't delete or remove it from the pleading on the basis that it isn't, they say, a justified part of a legitimate claim on their part. So they are saying that it is a real and genuine part of their claim against parties. Simply they're seeking to say, and we say artificially in order to try to get around the difficulties they have with the arbitration agreements, that that part of their claim is not demurrable or strikeoutable, but is properly subject of the arbitration agreement. And so that is, and when one sees how, nevertheless, it is interwoven with the bribery claim, with the dishonest assistance claim, with the unlawful means conspiracy claim, never mind when one comes on to all the remedies that the Republic is seeking, and which we've addressed in more detail in our case. When you come on to those as well, requirements of dishonesty, requirements of proving, for example, inequitable compensation, that the Republic has in some measure suffered a loss for which it ought to be compensated. All of these will engage and involve an analysis of the legitimacy of the supply contract, the materials and equipment to be provided under it, the price at which it was to be provided, and the benefit that the Republic has got from that. So the substance, we say, of the claim which my clients have to meet on bribery and dishonesty as they impact the various claims brought against the respondents is the matters which they have alleged in relation to the circumstances in which the supply contract has been entered into. And to say that somehow the circumstances and manner in which the supply contracts were entered into, their terms, their commerciality, are not engaged by their other claims, including the bribery, the dishonest assistance, and the unlawful means conspiracy, and the remedies across the board, is simply artificial for the reason explained by the Court of Appeal. It is the substance of the case my clients have to meet on bribery and dishonesty that I have been focusing on in relation to those extracts from the pleadings. And clearly, if you look at the supply contracts, arbitration agreements, those matters are, in our submission, clearly disputes arising in connection with the project and disputes, controversies or claim arising out of or in relation to the contract. Because all that we have been debating and discussing is related to the question of whether the contracts, the supply contracts, were legitimate commercial transactions or, in effect, a vehicle for bribery and fraud. And we have dealt with it in our defences, and in particular, if I may, in view of the time, refer your lordships to certain passages of those pleadings, but take you only to one in relation to each of the contracts. In the defence at paragraphs 191 to 193, paragraph 194, and paragraphs 214 to paragraph 205 to 214.4, but especially if I can refer your lordships to 214.4a.
Just repeat that, would you? Especially
214.4a.
Okay.
And part of the reason is this paragraph comes in.
Could you give us the electronic page number?
I'm so sorry, my lord. 559.
Thank you.
And that, in relation to the pro indicus, engages directly with the allegation that the bribe was all wrapped up with the pricing and commerciality or legitimacy of the supply contract. That is in relation to pro indicus, and if in relation to ematum, the same case is advanced in paragraphs 240 and 242, but particularly at 248 on page 568 of the bundle, which again adopts paragraph 214. And similarly in relation to MAM, the paragraphs at 265, 267 and 268.2 and .3, but in particular, again, 273, which is at page 574, again repeats paragraph 214 involving all of that.
All this shows is you're denying the allegations that aren't relied on against you. Well, one of the paragraphs starts, insofar as it's alleged, it's denied. It's not alleged now, so we can forget about that for present purposes.
The difficulty is how in practice one works through and separates the allegation in relation to the IFA.
That's a problem for Mr. Justice Knowles.
Well, with respect, we say no, because the way in which the allegation is interwoven with the other claims means that insofar as it is dropped in relation to the IFA, then all those other claims likewise fall to be referred to arbitration. Because the IFA claim is a core part of those other allegations. And you can't divorce.
I don't really see that. All you'll have to do is to go down the checklist in novice-ship and say, was there a payment made to Mr. Chang? Yes. Was it one that put him in a position of conflict of interest? Yes. But was it disclosed to his principal? No. Follows it was a bribe, if that's what's proved, unless something is demonstrated to show it didn't after all put him in a conflict of interest, because it was because receiving 45 million or whatever it was for something else.
But it is...
Even if it was for something else, it still looks like a conflict of interest to most people.
Well, fortunately for your lordships, that's a factual decision which doesn't need to be decided at this level and on this issue.
Clearly not.
No.
But I note the indication from your lordship. But the fact is, my client's case is that they are genuine payments for other reasons. And part of the analysis of whether they're in conflict or not inevitably involves the way in which the Republic advances the case to say that the supply contracts were vehicles to procure these payments for fraud, for bribery. That is what they say, and it infects all the other parts of their claims as well. If I can just briefly deal with the test point which your lordship raised with me yesterday as to whether they were different tests. All we say about this, and we would simply give your lordships two references on the authorities, that it's not just the way that it is pleaded, but it is at least the way that it is pleaded. It may also go further than that, and you look to the substance when applying the Section 9 test. In Ruhan, Mr. Justice Popplewell, paragraph 43.4 at page 3109 in our bundles, says you look at substance rather than simply the form, i.e. you look at the form, but you also look at substance. And Mr. Justice Andrew Smith in Lombard, at paragraph 14, at page 2645 of our bundle, you look at the substance to prevent the claimant circumventing by artificiality.
So which paragraph?
I'm so sorry, my lord. Paragraph 14.
14.
At page 2645.
Don't apologise, it was me being slow. Thank you.
I'm conscious I'm throwing a lot of numbers out. Therefore, from the point of view of the analysis for Section 9, you start clearly with the pleadings, and what is on the pleadings is a relevant matter for reviewing whether the proceedings are brought in respect of matters that are agreed to be referred to arbitration. But the court is also entitled to look beyond that for the defendant's case to consider whether in substance there is something beyond that which engages with the arbitration agreements which have been entered into. So the theorising of the Republic as to how they might differently present their case, excluding the allegations which centrally engage the supply transactions, the legitimacy of them, the commerciality of them, and whether the payments were structured in such a way as to enable bribes to be made or not, it is, in our respectful submission, apparent from the way in which it's set out. The arbitration agreements are in wide terms, and it's all very well to use the presumed intention of the parties, but one does have to start with the words used in the agreement between the parties, and to be careful not to stray too far from the normal and ordinary meaning of those words in order to give a different effect to the scope of what is to be included within those arbitration agreements. Now, my lords, I was then planning to say some additional matters in relation to ground 2, stage 1. In some ways, we can take it very shortly because we really don't say this arises at all. This is what we refer to as the Trojan horse, which is designed to make it look as though there was a real point of law involved in this case when there isn't really a point of law at all. We deal with it in our case at paragraphs 103 to 108, and this is the Republic's argument that the defence of the validity, etc., of the supply contracts was not a matter in relation to which these proceedings have been brought, and it appears to rest on two criticisms of the Court of Appeal judgment which are misplaced and involves tilting at multiple windmills. First of all, because the Court of Appeal did not apply the test in such a way as to encompass issues that were peripheral to the substance of the dispute between the parties. On the contrary, the Court of Appeal was very clearly of the view, and with respect we say rightly, that the matters engaged by the IFA, both as to claim and defences to that claim, also lay at the heart of the matters in respect of which proceedings had been brought against the respondents in respect of the other claims. So it was the Court of Appeal proceeded not on the basis that these were peripherally engaged, and therefore that the point of law that the Republic raises might arise. Their view was that they were centrally engaged. Secondly, the Court of Appeal did not differentiate, we say, between Ruhan and Tomalugan in the way the Republic now seeks to do. The Court of Appeal decided the case not on the basis that the matters agreed to be referred to arbitration arose tangentially or peripherally in these proceedings. On the contrary, the Court of Appeal formed and expressed the clear view that the matters agreed to be referred to arbitration arose centrally in these proceedings in respect of the claims against the respondents. So 3 points. Firstly, is there a real difference between Ruhan and Tomalugan? We say no. Secondly, if there is, which is to be preferred, or is some other test or analysis to be preferred? And we say if there is, then Ruhan is to be preferred on the basis we say that it was clearly intended by Mr. Justice Popplewell in the words that he used. And thirdly, if some other test or analysis were to be adopted, other than the approach adopted by the Court of Appeal, would it make a difference to the outcome in this case? Our answer to that is no. The approach of the Republic on this ground appears to be to argue that Ruhan misstates the relevant principles. This is not what the Republic argued below, and we deal with that in our case at paragraph 36 and footnote 36, where we give the court the cross-reference to the skeleton argument before Mr. Justice Waxman, at the citation there given. We also give, with apologies, my lords, the wrong reference to the Republic's skeleton argument.
Sorry, could you? Sorry, I'm awfully sorry. Could you just
page 89 of the key documents bundle.
89. Thank you. Yes.
And it's paragraph 36, which at the end has a cross-reference to footnote 36, which is at the bottom of the page.
Yes.
And on the second line, the reference to the Republic's skeleton argument before the Court of Appeal should be to paragraph 68.2.3, footnote 53, at bundle 1010. And also we rely upon the Republic's oral submissions. So the starting point...
So do we delete paragraph 17?
I'm so sorry, yes,
reference
my
to
lord,
991. Thank you so much.
And so the position in relation to this alleged ground of appeal based upon a distinction between Ruhan and Tomalugan was not one that the Republic had attached onto until the appeal to your lordships. They had previously treated the two tests as in effect comparable and giving rise to similar effects, as we say is in fact the correct position. The Court of Appeal judgment, we say that concluded in paragraphs 85 to 90 that the IFA was indeed a matter within the scope of the arbitration agreements, as conceded by the Republic, but tested nevertheless by the court. And the Court of Appeal then went on to consider whether the IFA was a matter in respect of which proceedings had been brought against the respondents and concluded that it was.
So the reference you've given us in the skeleton seems to be really just addressing the pro tanto point, doesn't it? You've taken us to the, this is right, is it, page 1010, to the Republic's skeleton before the Court of Appeal, and you're saying that they're raising a new point here, and you demonstrate that by reference to the skeleton. And is this right? The paragraph, it was footnote 53 you were referring to?
My lord, yes.
And that, but the text there is referring to the pro tanto point, isn't it?
But my lord, my point is simply that the only suggestion, as between Ruhan and Tomalugan, that there was anything to be considered in relation to it, was that which was set out in paragraph footnote 53. There was no suggestion anywhere in the skeleton argument that Ruhan was somehow the wrong test and Tomalugan was somehow the correct test.
I see. Right, okay.
So I have given you the reference to where
that's really just the only reference you say in the skeleton to the... I see.
I'm sorry, yes, there's no suggestion that at no point did the Republic take the point before the Court of Appeal that there was a relevant difference between the two tests in the two cases. And the Court of Appeal, as I say, having at paragraphs 85 to 90 concluded that the IFA was indeed a matter within the scope of the arbitration agreements, then went on at paragraphs 91 to 98 to consider whether the IFA was a matter in respect of which proceedings had been brought. Undoubtedly, in the context of that, they did, as my Lord Richards has pointed out, address the question of the defences which would arise in relation to the other allegations and how they would engage the matters covered by the IFA. And it is, in our submission, rightly conceded by the Republic in their case at paragraph 125 that a relevant matter for the purposes of section 9 can include reasonably foreseeable defences to the claim. So that appears not to be an issue between the parties. It is also conceded by the Republic in paragraph 126.1 of their case that the purpose of searching for reasonably foreseeable defences is that you then stay the claims to which the defences relate, not to the defence itself. there is, of course, no power to stay the defence, because the statutory power is in relation to matters raised in proceedings, and it is those matters which the court has power to stay. And so, as indicated earlier, my lords, the Court of Appeal didn't purely base its judgment on defences. It started with an analysis of the issues underlying the claims themselves. But in this context, the Republic then says, well, the court has to review the nature of the defences advanced, because the defendants could otherwise artificially manipulate the position by intimating defences, even legally irrelevant ones, concerning other contracts that happen to contain arbitration agreements. Well, that was not what the Court of Appeal said was happening here. That was not what can be said of the respondents here, and it's not clear that it's even suggested, there is certainly no clear articulation of it, that is what the respondents are doing here. The Court of Appeal in our submission rightfully focused rather on the artificial manipulation by the Republic of its claims in an attempt to avoid the impact of the arbitration agreements to which they were parties. And a lot of the debate which we are having here as to the scope of the pleadings and as to what might arise or not arise is the consequence of the way in which the Republic has been seeking to manipulate its pleadings to get around the impact of the arbitration agreements to which, by definition, on the assumptions we proceed, they were party and by which they are bound. And what we say is simply the court will be astute at a Section 9 hearing to ensure that it's not being manipulated by either party, advancing artificial cases to avoid or engage, respectively, the impact of arbitration agreements which they've entered into. Section 9 requires that proceedings are brought in respect of a matter which, under the agreement, is to be referred to arbitration, and the court will, we say, not be so satisfied if the basis of the respondent's challenge is artificial, any more than the court will fail to be satisfied if the claimant seeks artificially to manipulate the pleadings to obscure the matter in respect of which the proceedings are in fact brought. And ultimately, of course, also because of the pro tanto effect, the proceedings will only be stayed to the extent that a matter agreed to be referred to arbitration arises in the proceedings. If it does not so arise, then the proceedings will not be stayed in respect of that matter.
Am I right to understand from your case that you agree that in identifying the matter or issue, one looks to the essential elements of the claim and defence that have to be pleaded as a matter of law?
One does look to the essential elements of the defence and the case, but one obviously, slightly the complication is what does one mean by essential? And all of these words are ultimately glosses on the words that are used by the statute. We accept, at the other end of the scale, that peripheral or tangential issues, which are not in fact therefore properly to be described as matters in respect of which the arbitrations have been commenced, are matters which the court is unlikely to regard as suitable for stay, for the very reason that they could not properly be described as matters in respect of which the proceedings have been commenced. But of course we say that that doesn't arise on our case. If the matters raised by the defendant were peripheral, it would not be stage one matters in respect of which the proceedings had been brought. The proceedings would rather have been brought in respect of other matters, or another matter, which the parties on this analysis did not agree to subject to arbitration.
Can we just look at your formulation at page 118? That's paragraph 1073B. This is where you refer to the essential elements of the claim or the defence. And you include in there a defence which goes to quantum. Is that right?
Yes.
I mean, is there any case in which it's been enough to look at not just reasonably foreseeable defences, but simply a reasonably foreseeable issue on quantum?
Well, not that I can point your lordship to. There aren't a great many cases on Section 9 in the first place. The parties have only identified about 6 or 7 cases.
But assume that the reasonably foreseeable defence doesn't raise an arbitral issue. Is it enough to justify a stay to say, oh, well, there is a reasonably foreseeable arbitral issue in relation to quantum if the claim succeeds?
Yes, in that sense, it's remedies which may be stayed in part. And if one takes by analogy the Tomalugan type situation of the unfair prejudice proceedings, one recognises that some bits of the matter may be stayed. Now, admittedly, the other way around in that sense, but nevertheless.
So you just stay the damages claim?
Yes.
Potentially?
Yes. We would say that you can stay, but and then it's a case management decision as to whether you proceed with the liability. So, for example, if a respondent said, my answer on damages is a complete answer to the quantum of the claim, the court might say, well, in those circumstances, let's find out if there's actually any money in this before we proceed to a complicated liability hearing, because the reality is that if we've established that through the arbitrators, there may then be no trial in relation to the question of liability, because if the arbitrators analyse the defence on quantum, the matter in relation to liability may cease, and therefore that as a matter of case management, not as a matter of Section 9, but as a matter simply of case management, is within the power of the court to control its proceedings in order to ensure that the matter is not unreasonably disrupted.
Yes, because in this case, I think the trial that starts in the autumn is a liability trial. Is that right?
The trial is in relation to these proceedings rather than the immunity proceedings, some issues of which are also being tried, is an everything trial, including even macroeconomic losses, everything. So, and we have to differentiate them because parts of 2 different sets of proceedings are being heard together. In relation to what are referred to as the immunity proceedings, where the claimant is the Bank of ETB under the third guarantee, and the Republic is respondent, it has claimed state immunity. There is a significant overlap in relation to the factual issues relating to the justification for the state immunity defence or otherwise, in particular as to the commerciality of the transactions, as to whether the Republic is entering into them in pursuant of its commercial activities. And in those circumstances, there was considered to be sufficient overlap between the factual issues engaged by that aspect of the immunity defence in the immunity proceedings to have a unitary trial of those issues with the full gamut of the issues, in our case, subject to whatever may be stayed, but also dealing in parallel with the second half of the Section 9 and all the issues.
Yes, because in relation to remedy, if there is a claim for damages on the basis that the guarantees are binding on are nonetheless binding on the Republic, then the Privinvest companies will have a relevant defence that you gave value for money in providing the items and services contracted for.
Yes.
And that would clearly be, I would have thought, an arbitrable matter.
Yes. We've touched on all of these in our case, and I don't have a lot of time to go back over them, but we entirely agree, my Lord, that in matters such as claims for equitable compensation, claims for damages, some of the key issues that are engaged are issues relating to the commerciality of the supply contracts, whether full value has been given for the payments received from the Republic and indeed benefit.
And you could seek declarations from an arbitral tribunal to that effect.
Precisely.
And that would not be a peripheral issue in relation to quantum.
Precisely.
Okay.
And in a way, Your Lordship, goes to the heart of whether there is a real distinction between Ruhan and Tomalugan, because, and in some senses also the Australian cases of tanning, although they are to be approached with caution because they're dealing with a different statutory wording which requires a matter to be capable of settlement, which could be a more limited concept than simply matters. But matters clearly includes disputes, and any dispute or matter which the arbitration agreement has consigned to the, or by agreement is to go to the arbitrators, if such a dispute is raised in court proceedings, then it's a breach of the arbitration agreement to do so, and Section 9 protects the right of the party to the arbitration agreement to ensure that that goes off.
Yes, one might think that the essence of a matter is that it's an issue susceptible to be determined by an arbitrator as a discrete controversy.
Yes, and that is why we also say that there is no significant difference between Ruhan and Tomalugan, because clearly when Mr. Justice Popplewell is saying you look at the issues that arise, you search for the issues that arise, as we say in the case, it's all a question of looking at it, not the court of its own motion, which is how it seems to be being interpreted by the Republic, setting off on a search for any and every issue that arises. Clearly what Mr. Justice Popplewell had in mind was any and all relevant issues. Whether an issue is relevant or not will be because it's been raised by the defendant, because these applications are made by a respondent who says this dispute is subject to an arbitration agreement and therefore must go off. And it's obviously that Mr. Justice Popplewell's judgment is to be read in the light of that. You don't search of your own motion for any and all issues. You analyse the issues that have been brought before you by the respondent. You look at the pleaded case of the claimant. You look at whether, in fact, the pleaded case is artificial and behind it there is some other matter which the respondent rightly identifies as, in fact, emerging on the dispute between the parties, however articulated in the pleadings. And on the basis of that analysis, you then determine whether the issues that you have identified in that process fall within the scope of the arbitration agreement.
Just to go back to the scope of the trial in the autumn, just so I'm absolutely clear about this, are the Republic's claims for damages, common law damages and equitable compensation live issues in the autumn trial?
They are.
Thank you.
They'll be the subject of expert evidence, all of which is in train. Yes, so all of the issues in relation to the Republic proceedings, some of the issues in the immunity proceedings.
Thank you.
And
we have a particularised claim in relation to damages.
we have had a special pleading in relation to macroeconomic loss,
Right.
which was introduced subsequently. I'm not sure that that's on in the bundles, but I'll cross-check that and come back to you. But more widely, there is currently raging various disclosure dispute. We haven't had disclosure yet. We've had partial disclosure on a rolling basis. The final deadline for disclosure is supposed to be this Friday. It is apparent from huge numbers of issues have arisen. There have been CMCs at least once or twice a month for the better part of a year in order to address all of this. And so it is undoubtedly coming rather close to the wire in relation to some of the matters, but there is still disclosure awaited, for example, in relation to the use to which these the equipment supplied was in fact put by the Republic after receipt of it. and there is also a case, and there's debate about this as to the use to which it should have been put, and there's also a debate about the value that this equipment had to the Republic and how much value it would have had. There are also issues as to whether and the extent to which the full performance of the supply contract was prevented by, not least the way in which the Republic effectively changed its position when President Nyusi moved from being Defence Minister to being President and took over from President Gabuza, and effectively having negotiated them as Defence Minister, then negated them as President. And so there is a lot that's going to be addressed in relation to quantum. That is all meant to be encompassed within the October hearing. And I'm told the further particulars of the macro loss, I'm grateful, are at page 1191 of your bundle. Ultimately, we don't say that the Court of Appeal differentiated in the way that the Republic is suggesting that they did and should not have done by identifying peripheral matters. What the Court of Appeal focused on was the substance of the case in relation to both the claims and the defences to be raised in relation to those claims. It said that the matters which were to be raised both by way of claim and particularly by way of defences were indeed matters which were were indeed central matters and were therefore within the scope. So this is not a case in which that differentiation, this is not a borderline case in which any differentiation between a Tomalugan test and some different test actually arises. And one sees that perhaps in most clearly, but in multiple places, but most clearly in the judgment at paragraph 96. Starting at 95. The Court of Appeal in terms says the search under Section 9 is for the substantial issues to which the claim gives rise, including identified or reasonably foreseeable defences, and quotes Ruhan in this context, albeit without, for our purposes, the slightly less user-friendly name at the end of that paragraph. And then in 96, the Court of Appeal in terms says halfway down that the matters raised both by way of claim and defence are substantial and not peripheral or tangential matters. And so this is simply not a case in which the Court of Appeal has applied the wrong test, even if there were a difference between the two tests encapsulated by Ruhan and Tomalugan. What the Republic essentially seem to be doing, that where they seek to identify a gap or an inconsistency in approach, is in a case at paragraph 37, page 89 of the key bundle. They say that Mr. Justice, in the Republic's case at paragraph 37.2, which is in the core documents bundle at page 34, they say the reasoning of the Court of Appeal can be summarised as follows. 37.1, that there are two stages. Page 34 of the key documents bundle. They say the Court of Appeal held there were 2 stages of inquiry. Well, that's common ground, clearly that's right. And then they say in 37.2, in identifying the matters, the Court of Appeal appeared to adopt the definition provided by Mr. Justice Popplewell in Ruhan. And 3, namely any issue which is capable of constituting a dispute or difference which may fall within the scope of an arbitration agreement. The search is not for the main issue or issues, or what are the most substantial issues, but for any and all issues, and we say any and all relevant issues. And clearly that if one looks at it in context, as the Court of Appeal did, it is not saying peripheral and tangential matters arise.
So really it's an issue which is substantial and susceptible to be determined by an arbitrator as a discrete controversy.
Yes, we can see no purpose to Section 9 in requiring a matter to be arbitrated if in fact the issue that is raised
is irrelevant or insubstantial.
Yes. And we don't consider that either the way in which it's expressed by Mr. Justice Popplewell or the way in which the section itself is framed gives rise to any difficulty in relation to that. In 37.3, the complaint is that the Court of Appeal regarded the decision in Tomalugan as consistent with Ruhan. But as I say, it had not been suggested to the Court of Appeal that they were inconsistent, including by the Republic. But then a divergence is identified by the Republic towards the bottom of the page on 37.3. But then at the top of the next page, at the end of 37.3, demonstrating that there is actually no point of appeal here, they say, save that the Court of Appeal's later analysis appears implicitly to reject Mr. Justice Popplewell's approach. So the Republic seems to be saying that there is some criticism of the Court of Appeal for its identification of the test, that the Tomalugan test should be preferred to Ruhan, but then seems to accept that the Court of Appeal did not approach it on what they say is the Ruhan approach in any event. And so there really is, in our submission, no ground of appeal at all on this particular aspect. And at 37.4, again, we don't accept the analysis of the Court of Appeal in that paragraph of the Republic's case. We don't accept that 7 matters were identified, and nor did the Court need to do so. The attempt which the Republic make to strip out the circumstances surrounding the entry into and performance of the supply contracts and their validity by dint of abandoning the IFA allegations in this context, it was something which the Court of Appeal did deal with. So it took the IFA first because it had to satisfy itself that regardless of the concession, that the concession was rightly made. And that obviously makes sense because you don't send off to something to arbitration, which the arbitrators may then obviously conclude is not a matter within the scope of the arbitration agreements. The criticism that is raised is that in the second half of 37.4, the Court of Appeal judgment did not address whether there were other more granular matters that arise for consideration at the first stage of the inquiry per Ruhan, or whether any of the matters identified are ones in respect of which the proceedings are brought, which was simply assumed. Well, we say that's not a fair criticism of the Court of Appeal's judgment. They did indeed identify the claims in respect of which could be treated as matters in respect of which proceedings had been brought, and they concluded that the matters in respect of which the arbitration agreement covered were such as to encompass or be equivalent to the claims which were identified. If and insofar as greater granularity is required, well, that is obviously always something that can be done. It's not something that Mr. Justice Waxman has effectively done, because apart from anything else, we can object or criticise that judgment for other reasons, which of course have already been dealt with in the Court of Appeal. But fundamentally, of course, Mr. Justice Waxman did not conclude that the IFA or the unlawful means element of the IFA was within the scope of the arbitration agreement. And clearly, his judgment is acknowledged by the Court of Appeal and by the Republic to be wrong in that respect. So one is not in any sense left with the relevant analysis in the first instance judgment, and the Court of Appeal judgment, we say, is to be commended for the way in which they did approach the matter. It first of all took the matter of the IFA, it looked at that through paragraphs 84 to 90 of the judgment, and it concluded on, we say, unimpeachable grounds that the IFA was within the scope of the arbitration agreements. And what the Republic then sought to do was to argue that the IFA was not a matter in respect to which the proceedings had been brought. And that was addressed in paragraph 91 of the judgment. So again, the Court of Appeal has impeccably gone through the different stages required of the process in order to identify and apply the relevant Section 9 test. Of course, what the Republic had argued before Mr. Justice Waxman, was that the IFA and the UMIFA were not within the scope of the arbitration agreement, and that was the switch of position in the Court of Appeal on the part of the Republic to get round the difficulty of the arbitration agreement, although what they did seek to argue in the Court of Appeal was that although it was within scope, it was not a matter with which the proceedings were concerned, and what the Court of Appeal in its judgment at paragraphs 91 and 93 to 98 dealt with is whether in fact it was indeed necessarily a matter in respect of which the proceedings had been brought, and concluded that the IFA claim was an integral part of the other claims that the proceedings were in respect of, and that they had all been agreed to be referred to arbitration. The Court of Appeal did not analyse the legal relevance of the supply contracts to the issues in dispute alone. They also looked at it from the point of view of the defences. So they covered both aspects of that as they were entitled and bound to do. The Court of Appeal did indeed ultimately conclude that matters were within scope and were matters in the conduct of the matters in respect of which these proceedings had been brought. What the Republic essentially complains about is that they don't like the conclusions that the Court of Appeal reached as a matter of fact in applying the legal principles which they had identified to the facts in question. We, for reasons explained, we say that that's not a valid criticism, but nevertheless, it's certainly not a point of law as to how the Court of Appeal approached it. Ultimately, if one bears in mind that the Republic is a party for these purposes, the question is, could the issues that the Republic is bringing in these proceedings in relation to the respondents be ventilated and determined by the arbitrators in relation to the various different arbitration agreements? The answer to that is simply yes. And therefore, in that sense, they are substantial and they are disputes capable of resolution by the arbitrators pursuant to the arbitration agreements. Yes, I've already dealt with our case that the respondents' defence does not accept that the or the respondent's defence to all of the claims addresses the elements underlying those claims and in that sense covers all the matters that are identified by the Court of Appeal as matters that are arbitrable. Now, I don't know whether it's helpful for me to take you further in relation to Tomalugan and Ruhan. What I did just want to do briefly was to identify various points in relation to the authorities and the position on the law. The pro tanto approach is obviously something that is recognised by all parties as having the impact of the potential for fragmentation. That is, as acknowledged, the inevitable potential consequence of giving effect to international obligations to respect arbitration agreements that the parties have entered into. And the ultimate way in which that is dealt with and has to be dealt with is by reason of case management to deal with the proceedings that are left that are not to be referred to arbitration, but that is ultimately the question of the giving effect to the rights of the parties, and it's not something which should then influence, as it were, iteratively, as the Republic suggests one should, the scope of the agreement, let alone, and bearing in mind this is the part of the case we're on, ground 2, which is the first part of the legal test, let alone should the question of whether the proceedings have been brought in respect of certain matters be somehow affected in its analysis by the extent to which fragmentation may follow. Fragmentation is an accepted consequence, potential consequence of the application of Section 9. The existence or otherwise of fragmentation does not inform the construction of the first stage of Section 9. Now, I wasn't proposing to say anything more about Ruhan or Tomalugan at this stage, unless your lordships would find it helpful. I was just going to reiterate in relation to the Australian jurisdiction the reservation that one needs to approach that with caution, as I've mentioned, because they're dealing with a differently worded statute.
Yes, your position in relation to Tomalugan and Ruhan is that Mr. Justice Popplewell should be understood as incorporating in his or any issues the question of relevance and substance.
Yes.
Yes. So you're saying with that there is no difference.
Yes.
And you're suggesting in relation to the Australian jurisprudence that Tanning and the other cases are based on differently worded Australian statute.
They are, and it's not necessary for the court to address whether they come to a conclusion that would not be justifiable on a Section 9 approach. But they are clearly limited or restricted by the wider wording of the statute which they are dealing with, which requires the matter to be capable of settlement. Whether that in practice gives rise to difference is difficult to see. It certainly doesn't have any impact upon the issues before your lordships.
Yes.
If there is a difference, I'll deal with this very briefly, we say that the greater granularity, if Mr. Justice Popplewell's approach is that of greater granularity than Tomalugan, let alone Tanning, then greater granularity is to be preferred because it favours arbitration and gives more respect to the autonomy of the parties which is what Section 9 is respecting and is the policy matter that underlies Section 9. And therefore, the better case at stage 1 is to read it broadly when analysing what are the, not broadly in the sense of taking too big a picture, but a granular picture of it, identifying the issues that have been raised. But ultimately, given that our primary case is that there is no difference in practice between the two tests, I am drawing a very small distinction between the two, if there is such, and if there is, then Ruhan is to be preferred as a matter of English authority. Ultimately, for the reasons I've indicated, and appear to be accepted by the Republic, the Court of Appeal applied a test which would satisfy Tomalugan. So, from a point of view of grounding a challenge to the Court of Appeal judgment, it simply doesn't work on the facts. I was going to come on now briefly to take on a little bit more in relation to the Section 9 first stage, specifically in relation to the different matters or causes of action that the Court of Appeal found: bribery, dishonest assistance, knowing receipt and linked to that proprietary claims, conspiracy to injure, and I'll touch on account of profits, although that is effectively absorbed within it. I've broadly dealt with the general principle which infects much of this, which is that in each of these cases there is the underlying issue of whether the supply transaction was a legitimate commercial transaction justifiable on its terms. It picks up, for example, the points on damages which my Lord Hodge has touched on this morning, and in each of those the legitimacy and the commerciality of the supply transactions, what was to be provided under them, what benefit the Republic was to be obtaining under them, are matters that are on any view engaged between the parties and will in any view be the subject of debate in the autumn in these proceedings, in order to ascertain, if nothing more, at least the very issues to do with damages that the Republic raises in their claims, but of course we do say that it has a wider impact than simply the damages claims. Yes, I've dealt with that in the discussion this morning.
Just to make sure I understand, if this court were to hold that there was not a basis for a stay in respect of the claim that the Republic is now bringing in relation to liability, but there was a basis for a stay in relation to damages because of the matter I put to you.
Yes.
What effect, if any, would that have on the ultimate trial?
I regret to say that apart from one very small matter, which is the admission of Swiss law evidence on the parties issue, nothing that your lordships conclude will have any impact in reality on the scope of the autumn trial.
Whatever we decide, it won't have any impact, as I understand it.
That's what I thought you were going to say.
On any of these issues.
As I say, with the exception of the Swiss law in relation to parties, because if there may still actually, if your lordship is addressing the fact that insofar as there are questions of Swiss law arising in relation to the construction of the supply contracts, those two would be addressed by Swiss law expert evidence in any event. But there would be a limited reduction in the scope of the trial in this sense, that if your lordships were fully against me, which in a sense it given the concession, it's still recognised that at least the IFA and the UMIFA can't be dealt with as against my clients in the autumn. If your lordships were sort of partly against me in the sense that some aspects of liability, your lordships were of the view were not engaged, but the defences in relation to damages, for example, meant that the damages issues should go to arbitration, then that still would have no diminishing effect on the trial in autumn.
Yeah. I thought that was what you were going to say, but I wanted to make sure that was your position.
Yes, indeed. The case management decision of Mr. Justice Knowles in relation to how the case is to be structured does somewhat limit the practical impact of the appeal on any view. So, for example, in relation to the bribery allegation, the claim for restitution, as money hadn't received, might not, your lordships might conclude is not a matter that if your lordships are against me on the more fundamental principle in relation to bribery, but as a matter of pure defence to a monetary claim, your lordships may say, well, that's not a matter that goes to arbitration, but the damages for any actual loss suffered by the principal from entering into the transaction, in respect of which the bribe or secret commission was given or promised, it is fundamentally, obviously, a matter that does go to the matters arising in respect of the supply transactions, would obviously be a matter for the arbitrators to address on the basis that the Republic is a party, a question of whether any loss occurred in relation to that, and the Republic would have to elect between those remedies prior to final judgment being entered, which means that from a practical point of view, there may be certain complex implications from one part of it being addressed by one jurisdiction and the other by another. Dishonest assistance.
Can you just refer simply a question of damages to arbitrators?
Absolutely. You could have a declaration as to what loss was caused by an identified breach. There'd be a dispute as to what sum was payable in consequence of it.
Or you could be more granular and refer an element of the damages claim, which would be your defence that the supply contract gave value, and any damages claim would have to be reduced by reference to the value received by the Republic.
Yes.
And similarly, there may be issues about whether the Republic has thrown away, from the way it's handled,
yes,
what you provided.
Yes.
And therefore inflicted loss on itself.
Yes. Well, all of those. And it's not so strange from a logistical analysis that might be the way in which things are done for this reason, that given the starting point, which is that the Republic is a party, given the second starting point, which is that the IFA and the UMIFA are matters that go to arbitration, the damages aspect of the consequences of something being dealt with by arbitration are in that context not being dealt with in isolation. They'd be being dealt with as part of a wider arbitration in any event. Dishonest assistance we have dealt with at paragraph, in our case at paragraphs 80 to 83. And the only thing that I wish to add by way of supplement to what is there, identifying the fact that both, as we say at paragraph 82, one is the bribery point, which I've already gone over, I'm not going back over. 82.2, conduct in inducing to agreement to the supply contracts is alleged to be dishonest. That again is in relation to the liability. And then at 83, we've identified the remedies that are sought consequent upon these claims, and in the context of obviously equitable compensation, as well as liability to account. Obviously, the supply transactions are centrally engaged, and we say matters arising under the arbitration agreement in those supply contracts are centrally engaged. And
yes, so both in relation to liability and in 83, the quantification
exactly,
of the remedies.
Exactly. And the account for profit under the dishonest assistance claim has been clarified by the Republic as referring to profits under the supply contracts. That's in the further information, paragraph 67.1 at page 483 of your bundle. The knowing receipt and proprietary claims we deal with in our case at paragraphs 84 to 88, and I'll just pick up briefly at this point the.
I thought knowing receipt wasn't. I thought knowing receipt wasn't being pursued. So
the position in relation to that is it's not that it's not pursued. It's, as I understand it, it's that a slightly different tweak is being applied. It is said that obviously knowing receipt would involve receipt by the respondents of assets which are the assets of the Republic. And what is being said is, by the claimant, well, they don't claim anything under the supply contracts in relation to knowing receipt. But they haven't withdrawn the case of knowing receipt against my clients. They withdraw payments under the supply contracts from their claim, they say, because that would be subject to the arbitration agreements and therefore a stay. But what they say is the point that we make, namely that no payments were made under the supply contracts, would make their claim demurrable or strikeoutable. It doesn't make it a claim that has to go to arbitration. And so you have the very odd situation, as we understand it on their pleading, that they are saying, we are pleading and claiming against you for knowing assistance, for knowing receipt. We haven't arguably identified a coherent or complete cause of action in relation to that, because we haven't identified any sums that would be capable of recovery under knowing receipt, other than sums paid under the supply contracts, and sums paid under the supply contracts would be subject to the arbitration agreement. And so we are left, in relation to knowing receipt, with a claim, the entire defence to which it would appear, namely that it would be limited to sums paid under the supply contracts and no sums of the respondents have been paid, of the Republic have been paid under the supply contracts, and that would be a matter for arbitration in any event, is attempted to be sidestepped by the Republic saying, oh, but we still have a claim against you. It's just that we haven't got any, we haven't identified any monetary claim associated with it.
Well, unless they do that in good time before the trial in the autumn, it's a dead duck, isn't it?
Well, what we say is the proper approach, which is the approach the Court of Appeal took, is that given that that is central, the only way in which...
Knowing receipt?
Knowing receipt is... The only way in which the claim for knowing receipt could succeed is in relation to a matter which is, by definition, covered by the supply contract.
And which they're not pursuing.
And therefore, we say that the correct approach is the approach adopted by the Court of Appeal, namely to refer the claim and the defence, as it were, to arbitration and to stay the knowing receipt claim.
I see. So it's a pretty technical point, isn't it, really?
Yeah, well, the short point is it shouldn't be there on the pleadings against my clients. The Republic says it shouldn't be there, if you're right, because it should be struck out. We say the Court of Appeal took the right approach of saying, insofar as there is any claim under that, it's a matter for the arbitration agreement, and therefore we stay it. The result is the same. We say that the analysis is correct on the part of the Court of Appeal, and that is the result, should be retained. And therefore, the claim should be stayed, rather than it being left to a debate as to whether it's demurrable or should be struck out.
The only monies that the SPVs undertook liability for and the Republic guaranteed were monies paid under the supply contract. Is that right?
Correct.
Yes.
And the law in relation to conspiracy to injure by unlawful means, we've dealt with that in our case at paragraphs 89 to 90. There was a decision of the Court of Appeal in relation to that element of the unlawful means conspiracy, which we had said applies not to our clients but to the Credit Suisse team only. The Court of Appeal, with respect, we would say rightly rejected that on the basis that because of the joint and several liability nature alleged in relation to the liability for conspiracy to injure by unlawful means, that does also affect our clients. That is dealt with by the Court of Appeal in paragraph 102 of the judgment, and we don't challenge that.
So, yes, this was, they deal there with the concession you shouldn't have made. Is that right?
They do. And
I mean, I'm not quite sure I understand their reasoning in 102, but...
well, in any event, it's not...
You're saying you're maintaining your concession.
I'm sorry, my Lord.
Are you saying, are you adopting what the Court of Appeal have said?
We're conceding to the greater wisdom of the Court of Appeal.
Yes.
Yes.
You're conceding that the concession was bad.
Yeah.
Indeed, my Lord. And that is not, as far as we're aware, something which has been appealed to this court. And so that is the end of that matter. If I can just take the one small additional point in relation to the conspiracy to injure by unlawful means. If we look at that in the claim at paragraph 132, which is at 442 of the bundle, the case against my clients in relation to the alleged conspiracy is that my clients, amongst others, wrongfully and with intent to injure the Republic by unlawful means, conspired and combined together to defraud the Republic and conceal such fraud and the proceeds of the fraud from the Republic. And we say in relation to that, again, that if the Republic in fact got a perfectly good and commercial deal from the supply contracts, it is difficult to see how it can be said that they have been in any sense defrauded. And so that, the foundation of their claim in relation to unlawful means conspiracy, again, takes you back to the analysis of the supply contracts and their terms, and in identifying whether indeed the terms of the supply contracts were such as to defraud or harm the Republic, we say that that is a matter relating to the scope of the arbitration agreements. It's a dispute in connection with the project, or it arises out of or in relation to the supply contract, and therefore comes clearly within the terms.
So, 132, so basically you say that when it said that they combined together to defraud the Republic, that means to obtain the price under the supply contracts in return for services and so on of far less value.
Correct.
That's the point. That's what defraud the Republic means there.
Correct.
Yes, I see.
And, my lords, that's all I proposed to say on ground 2, stage 1. And I was then going to come on to deal with ground 1, stage 2. And I'm in your lordship's hands as to whether it's convenient to start now for 2 minutes or to pause and resume it to when.
Well, I can leave that to your judgment. You have a quarter of an hour more than your formal time because Miller exceeded his opening time by 15 minutes. So you have an hour and a quarter after the adjournment. Would that be sufficient for your purposes?
My lord, yes.
Well, in that case, the court will take the short adjournment now. Thank you very much.